Hello, dear students. Once again, uh, in front of you, this is your fifth number and the last unit, which is related with the laws governing merger and acquisition in India. Till now, in the previous four units, we have got the idea about merger and acquisition. Now, let us see the laws which governs merger and acquisition in India. You know that if there is the companies, if they are going for the merger and acquisition process, they have to follow the laws for the merger and acquisition process. So you see, there are regulations which govern Indian companies. So they differ on some of the points. If the merger and acquisition is related with private company or public company, listed company or unlisted company, or non-resident, foreign-owned or foreign-controlled companies or resident companies or operating in a specified sector. So you see the regulations, they can differ in some of the aspects because merger and acquisition, it can be related to the private company or public company, listed company and unlisted company, non-resident or resident companies, or the company may be operating in a specified sector. So the regulations may differ according to the situation. So the first law which governs the merger and acquisition is the Company Law, Companies Act 2013, and the section 230 to 240 of this act defines about the rules, orders, notifications and circulars for the companies which are the Indian companies, and the rules have to be followed by the companies, those who are looking for the merger and acquisition process. So here the manner is defined, the rule is defined, the way is defined. So in that way, the companies, they have to follow. So if any company, if they are looking for merger and acquisition, they will have to follow the section 230 to 234 of the Companies Act 2013, which governs the schemes of arrangements between a company, its shareholders and creditors. So the first law is the company law, which are to be followed. Section 233 of the Companies Act cover fast track merger. Fast track merger where two or more small companies and they are having the paid up capital less than 100 million and turnover less than 1 billion. A holding company with its wholly owned subsidiary. So you see, there is also the provision of fast track merger. And fast track merger in the case where there are two or more small companies and their paid up capital is defined, their turnover is defined. For them, there is the Section 233, which governs the fast track merger. Section 234 of this act permits for cross-border mergers. It means the Indian company, they can merge with the foreign companies. So there is Section 234, which tells about cross-border merger, where the Indian company can merge with the foreign company. So the conditions are defined there, and the approval from RBI is to be taken before going for the merger, cross-border merger. Then you see the next act is the Contract Act 1872 and Specific Relief Act 1963. They are also to be followed. The Indian Contract Act 1872 lays down the principle related to the enforceability of contract, and if there is a breach of contract, what can be the consequences? And a Specific Relief Act 1963, it defines about if there is any default, then it provides the recourse to the aggrieved party to enforce a specific performance of contract. It means if the two parties are involved and any of the party, if they breach the contract, in this case, there is the Specific Relief Act 1963, which will help to get a redressal in the case of breach. Which it means the party, they have not followed the conditions of the contract. Securities law. The next law to be followed is the security law, SEBI. SEBI Act 1992, which defines about the rules and regulations, and SEBI also talks about the substantial acquisition of shares and takeover. Regulation 2011. Takeover code is there. SEBI has defined the takeover code. This code restricts and regulations acquisitions of shares, voting rights, control in listed companies. It means any company which is looking for the merger acquisition, they have to follow the takeover code of SEBI, which has been brought in the year 2011. So in this framework, you see the existing obligation of first selling down to 75% and then attempting a delisting process as per the reverse book building process and has been scrapped. A new delisting threshold has been set at 90%. So you see the takeover code, which has been brought in the year 2011. And SEBI also talks about the listing obligations and disclosure requirements in the year 2015. Listing regulations, it means it talks about the comprehensive framework governing various types of listed securities. And these regulations laid down the condition to be followed by a listing company. And before making an application, NCLT, that is the National Company Law Tribunal. If you are looking for the merger acquisition, you will have to take you can say the approval from NCLT, National Company Law Tribunal. So you see this besides SEBI, there is the court, National Company Law Court, and the approval has to be taken. And next is the SEBI again saying through its regulation in the year 2015, about insider trading regulations. It has to be followed. And delisting of equity shares, this regulation in the year 2009. So this has to be followed in the case where there is a delisting of a listed company. Then merger control law. Merger control law in India governed by the Competition Act 2002, where the Section 3 covers anti-competitive agreements and Section 4 covers the abuse of dominant position. So if there is a merger acquisition, there can be the case of the dominant position. Other sections including 5, 6, 20, 29, 30 and 31 deal with various types of combinations, and CCI, they also govern the manner in which the merger and acquisition has to be carried out. So you see the laws which are related for the merger acquisition process in India, Company Law 2013 from section 230 to 240, they have to be followed because the circulars, the rules are there. Then Contract Act 1872 and a Specific Relief Act 1963. They are also to be followed because the merger acquisition process will lead to a contract, will lead to an agreement, a legal agreement, which means a contract. Security law, it means the SEBI. SEBI has defined about a takeover code. And NCLT is also there, and approval is to be taken from NCLT, National Company Law Tribunal, Merger Control Law. So I will continue about the same topic in the next video. Thank you for now. Just I have tried to shorten down the duration of the video so that you can better listen to the video. So I will continue the same topic in the next video. Thank you for now and wait for the second video, which I'm going to share very soon. So thank you for now. Keep listening about the laws which governs the merger and acquisition process in India. It is a very important topic. In future, being a manager, suppose if you go for the merger and acquisition process, you need to know all these things, the laws, the acts, and the governing bodies. Thank you for now. See you very soon in the next video discussing about the same topic.